Okay, so today we'll discuss contract part of a general paper. That will be question one. Okay, first and foremost, the first thing that you should do when you get the examination paper, don't read the text first, but rather you have to read what is the requirement of the question. Okay, for example, this question is like this. KK now comes to you and seeks your advice. So you must be clear, you are actually representing KK. Okay? So this is what is the requirement of your legal position. Okay? Because in law, we cannot advise like both parties. Okay? And you go straight to the question. Okay? This is your question A. You are asked whether KK has a claim for breach of contract against MM. And question B. If KK has a claim for breach of contract against MM, advise KK as to what remedies available and types of damages. Read it carefully. It's damages that he may claim against MM. Okay. And last but not least, often than not, they will ask you to draft a statement of claim. That one is every year question, repetitive question. So no doubt about that. So you are going to draft on behalf of KK. Okay. We go to the question itself to save time. I'm going to teach you how to read the question. Okay. Number one, this first paragraph often invites you to get the background information of the parties. Okay, you get what I mean? That is to say, who are them? Who are the plaintiff and who will be the prospective defendant? Okay, in this case here, it is clear from the facts that MM would be the defendant. But you have to read the question as a whole. So this is under the name and style of MM's hairdressing salon. Meaning what? She is a sole proprietor. Okay, sole proprietor registered under SSM. Okay, berniaga atas nama dan gaya MM's hairdressing salon. So this is MM legal capacity. Okay, whereas our client, the name is actually called King Kong, and he also is a business owner. You see this part, under the name and style of KK Toiletries. That is to say, he is also a sole proprietor registered under SSM. Okay, very important. Okay, after you get uh, the what we call the name of the parties, you must get to know their relationship. So what is their relationship? Okay, the relationship is as such. They know each other for about 5 years duration. Okay, in which KK is the regular customer of Meme. Okay, because KK appears to cut his hair under Meme for a couple of 5 years. And then KK also, during the conversation, MM actually does not know about the details of KK business, but through their conversation, he is actually aware that KK is in the wholesale business for these products. Okay, what this paragraph is trying to suggest to you in relation to breach of contract is that If let's say the defendant has knowledge about what are you doing, probably you can say the damage itself is within the contemplation of the defendant. That means to say the defendant, when she breached the contract, she should have known this will be the consequence that is going to occur. As simple as that. Okay. So next paragraph, normally they will start to tell you how the contract is being formulated. That means how they enter into a contract. So this particular incident actually happened on 31st May 2023. As this is a very ordinary and usual occasion, KK came to MM's hairdressing salon for just haircut. And during the haircut itself, MM was told by KK that KK secure a 3 years contract. 3 years contract to distribute toiletry products to three different hotels. And on top of that, this 3 year contract require KK to supply shampoo. As the text itself reflects, MM is also doing the hairdressing shampoo. It happens that MM got the source to supply shampoo to KK. So this is the whole version of story. And suddenly, MM got interest because they are chance to collaborate with KK for a joint venture, something like that. Okay. And let's say MM could supply the shampoo to KK, and then KK will be the middle person since he already secured the 3 year contract with three hotels, isn't it? So MM could gain profit from this sort of collaboration. So as simple as that. But at this moment of time, you must be very clear who is the offeror and who is the offeree. Okay, who accept the deal? Who offer the deal? Okay, at this moment of time, there is actually no contract yet. This is merely some sort of invitation to trade, or rather, it is just some sharing. Why I say there's no contract formation is that the terms are not clear. The obligations of the party have not been fully laid out yet. Okay, but whereas from the third paragraph onwards, from the third paragraph onwards, you can see that there are some details coming on. You can see the details are coming on. Okay, in which KK informed MM that he will need supply of, you see, every single word are very important from this third paragraph onwards. He will need good supply of good quality shampoo every month. And you can get the exact obligation, what KK need to do and what MM will need to do. This is how. Okay, what he need will be 50 ml packs shampoo. The brand name is KK shampoo, and the total amount of the supply will be 60 units every month. And the date to start this contract will be 1st of November 2023. So you can see now who is offering who. I would personally commented that KK offer or propose MM to enter into an agreement. Subsequently, I'll tell during my answer sharing session. Okay, and immediately you can see the word that I have highlighted. Okay, no written agreement was signed by the parties. Okay, so how does it affect the deal between the parties since there is no written document? That means to say there's no black and white documentation about what are the exact deals of the party. Okay. This invites you to critically discuss it in your examination. Okay. Subsequently, MM sourced the shampoo from this Sendirian Berhad, B shampoo Sendirian Berhad. Okay. And everything went smoothly for about 4 months, up to the point that there is some fluctuation in the exchange rate, in which the US dollar price had already increased. B shampoo, as the third party that supplies shampoo to MM, cannot agree to supply the bottle shampoo at the initial agreed price of 4.5 ringgit per pack. Okay, so the capital, the model, okay, model atas pihak MM already increased due to the increment of that particular unit price. So if MM continuously supply the said thing to KK, it will result the loss on her part. So what she did, so MM actually call KK to inform her that to inform KK that unless KK increase the due monthly uh, from 300,000 ringgit to 360,000 ringgit, MM could not longer supply the shampoo to KK. Okay, you can see there is some sort of anticipatory breach. The real breach has not occurred at this moment, but this is about to happen. Okay, in return, KK did not actually accept the deal. KK was very angry and threatened MM that he will sue MM if she stopped the supply. Okay. And we move further, you can see the relationship gets sour because KK did not agree to pay the increased amount of price. So therefore, MM does not want to bear the loss. So what she did without any notice, now you can see there is no warning, no nothing. Okay, she stopped supplying the shampoo to KK from this date onwards. Okay, this date. Okay, and as a result, because there is no supply, KK cannot fulfill his contractual obligations to the precedent contracts that he had entered with the third parties, the three hotels. Okay. So as a direct result, the three hotels terminate the agreement with KK for the supply of toiletry products. And as a result of this particular termination, and this part talks about the damage. What is the kerugian ataupun kerosakan yang dialami oleh KK? So this is calculated from 1st of April 2024 onwards. And apart from this particular three contracts, KK also suffer from some loss because he's in this industry for about 10 years duration. And other customers, for example, the hotels, the gym operators would have heard about the so-called the trust issue were being affected as KK terminated by those three hotels. So as a consequence, they will stop doing business with him as well. So these are the damage suffered by KK. Okay, the story itself is quite clear, but it's just that how you want to draft your answer. In my personal opinion, this year question is not too complicated. They just want you to thoroughly, comprehensively discuss whether there is existence of breach of contract, and if you could have established the breach of contract as the cause of actions on part of KK, what is the later advice that you will need to give to KK to help him to solve this problem. This is your task here. Okay. In order for you to answer this question, first and foremost, please be clear with the parties involved. So the parties involved are number one, KK, and number two is MM. But both of them are actually sole proprietor for a business. Okay, this one is you must remember, you must remember. Okay, and the cause of action is breach of contract. Okay, so you assume the role as the KK's legal counsel. So you're on behalf of KK. Okay. So for you to show a breach of contract, actually it is a little bit similar with tortious claim. You have to prove certain elements. In order for you to prove there is existence of breach of contract, okay, KK will need to prove to the court on balance of probabilities, because this is a civil case, on the following issues. Number one, there must be a contract between KK and MM. Okay, this is the first part. And then subsequently, there must be a breach of contractual terms by MM. And third element would be KK have suffered damage due to the breach. Okay, so you go on by analyzing the factual scenario. Okay, you make it sweet and clear to the examiner at the first instance that KK is advised there is a breach, there is a valid and legally binding contract because, okay, number one, then you go through according to the factual scenario. Don't go just talk about the legal, what we call the legal, how to say, the legal principle without relating to your facts. This is very wrong, and you don't have the luxury of time to do so during examination. So you straight away go to the point. On 31st of May 2024, what happened? Okay, KK offer a business deal about a supply of shampoos to MM. And this clearly is a proposal under the meaning of Section 2A of your Contracts Act. Okay, always remember, and if you start flipping your Contract Acts, you can see 2A. Okay, see, when somebody offer he wants to do things or prevent himself to do things, he's said to make a proposal. So this one is very important. Okay, you put it this way. Then subsequently, he lay out the terms and condition, isn't it? But you don't discuss first because you want to make the answer sheet very systematic. Okay, the said offer was accepted by MM on the same day itself, and therefore it becomes a promise. Okay, so this you look back into section 2 subrule B of your Contracts Act. Okay, on top of that, you can also refer to my YouTube channel. I have a slide explaining how this is working. Okay, this acceptance on part of MM is unqualified and absolute. Why I said so? When KK layouts the 60,000 unit of 50 ml mini size pack shampoo and with good quality, and he's going to pay the amount of 300,000 ringgit per month, there is no variation. There is no counter offer on part of So all the deals and all the terms have been duly accepted by in just single setting without further question, without the need to subject to contract. It's already being accepted. Okay. So at this moment of time, there is a promise already. Be clear about your legal position. Okay. So next, what you need to do, you discuss what is the exchange of due. This is mentioned in the facts, in which KK will need to supply, will need to supply 60,000 mini pack shampoo, 50 mil, okay, from 1st November onwards, and then subsequently in return, KK will pay monthly sum of 300,000 ringgit. So this part itself, you can see exchange of value. Consideration in Bahasa Malaysia, it is called balasan. Apa parti yang memasuki kontrak ini akan dapat. Okay, so this is what is going to get 300,000. KK will get 60,000 unit of shampoo. So this is consideration. Okay. And when the consideration is there, there will be what we call agreement exists. You get me? Okay. But subsequently, you must also critically evaluate and analyze whether this sort of terms, this sort of exchange value thing is legal or not. You have to challenge the legality of the trade of shampoo products. I will give following comment. Okay. Looking at the trade of shampoo products, there is no law in Malaysia that strictly forbids it, isn't it? So the consideration is lawful by the meaning of Section 24 of Contracts Act 1950. Okay. And then, if let's say this is a lawful contract, Section 2, Subrule H further mentioned that an agreement enforceable by law itself automatically form a contract. Be very, very clear with the wording that you use. Okay? Contract at this moment. Okay. And then subsequently, you go on to discuss the other element. That is the intention to create legal relationship. You put it very simple. Both parties are just acquaintance and they are entering this contract for commercial purpose. That is business deal. So normally, the court will presume any type of relationship other than domestic relationship will presume the existence of intention to create legal relationship. So you can use the Kajang Sri Rock products against Maybank case, but you do not need to elaborate further because you need to move on already. Okay. After that, you need to discuss whether both parties are capable individuals or sendirian berhad to enter this sort of contract. You have to assess their legal capacity as well as their competency. Okay, so in which to say, from the background of the facts given, KK is the sole proprietor for KK Toiletries, while is entering the contract as the sole proprietor for MM's hairdressing salon. So this is not disputed under the law that they both have legal capacity to enter into this contract and they are recognized as competent party pursuant to Section 10 of Contracts Act. Because why I say so? Because there are absence of facts suggesting that they are minor or something wrong in their mind. So that means to say they are okay, to enter into this contract. Okay. Subsequently, every contract must be entered according to the free will of party. I and you enter into a contract, I must not be misled. I must not be cheated. I must not be forced. I must not be, etc. Okay, there must not be mistake. So free consent, you refer to section 14. Then you conclude that there is no vitiating factor. Because if there is any vitiating factor, it will cause the contract to be voidable from the beginning at the option of the person that is innocent. Okay, you get what I mean? So, nevertheless, you don't think that, let's say, for example, the contract is formed at this moment, then everything will go smoothly. No, there is one technical glitch that you need to advise KK because the contract is entirely just through the air. There is no written contract in black and white. So, how do you prove? Fortunately, fortunately, Malaysian court does recognize oral contract. So if the oral contract, all the so-called the elements above are fulfilled, then you can safely conclude that there is a valid enforceable oral contract between the parties. You can refer to the case of Kong Hoi Kiat against Raina Ba. This case is also, I think you can see in your PP paper, it's about a breach of a solicitor and client agreement. And that agreement is an oral agreement. Okay. And furthermore, this one I highlight in what we call in um, red color is because if you do know this, you better don't write. Be safe. Okay. Because I have already told you your job is to advise KK. So now you have an oral contract. And certainly there is a chance that MM will deny entirely the existence of this oral contract. So how you want to prevent, how do you want to stop MM to do so? Okay. On the facts, you can say there are four previous transactions, and previous conduct. So MM should be stopped from making claims that she was not aware of the existence of this contract. But like I have told you, the reason why I strike it through is because if you do not know about this principle, the 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 how to call the tip to answer this GP paper as well as your other CLP paper. Number one rule is to play safe, not to play smart. Okay, this is not the field that you want to take the risk. So if you do know, don't put. Okay, if you know and you are sure, you put. Okay. Next element, we have to look at terms. Okay. In regards to the contractual terms, which means obligations of the parties. Things need to be performed or things need to be abstained from doing. These are called terms. Okay. So the terms derived from the facts are just the regurgitation of the facts that we have discussed before. And I will conclude that all these express terms in terms of the description, the quantity, the brand, delivery timetable, monthly, and payment will be classified as fundamental terms under the reasoning in Ching development against Tapak Hai, as it goes to the root of the contract on bargain test. Okay, many of you may get confused. What is the meaning of fundamental term, less important term, innominate term? Okay, these terms are actually vaguely defined by the court. Because why? Every contract itself, to me, for example, if I am buying a Tesla, a car Tesla, my oral contract with the sales representative of this Tesla is that I want a red color premium Tesla. You see or not? The red color and also premium will be the fundamental terms that goes to the root of the contract. Why? Because I want to give it to my wife who love red color and a high premium version car. If the sales representative of Tesla company deliver a white color Tesla, even though this is still a Tesla car, I'm entitled for termination because you have breached the fundamental terms. So by the bargain itself, by the negotiation of the parties, these are the so-called fundamental terms that must be fulfilled by all parties. You see or not? Okay. Okay. Next, we will discuss about the breach. The breach is very clear. The fact that MM were required to supply KK Toiletries 60,000 units of shampoo every month, isn't it? When she failed to do so, refused to perform, disable herself from performing her promise in entirety. Okay, MM will be deemed as the defaulting party. You all can follow me. I see quite quiet, and the number has reached 100 page. You all can understand me so far?
Can, doctor?
Can clear or not? Or am I too
Yeah, clear,
speaking
very
too
clear.
very clear? Okay, good lah. Okay, we'll go on. Okay, the breach has occurred, and this is a fundamental breach, Okay, because KK no longer supply any shampoo to the KK. Okay, so pursuant to Section 40 of Contracts Act 1950. So this is reflected by her own conduct to refuse to supply the goods to KK. And you can refer to one case, SPM membrane switch against Kerajaan Negeri Johor. Okay. As a consequence, what happened is that KK was put into damage. That means he suffered loss not only from the deals that he had entered between the so-called the three hotels, as well as from some sort of reputational harm and perhaps some anticipatory breach from his other usual customer, for example, the gym operators and some other hotels. Okay, so there is damage suffered, and the issue of damage will be elaborated in answer 1B. So this is the way that you explain things. Don't spend too much time to talk about the test, the legal principle, etc. Okay. So in view of the above mentioned, what we call the discussion, it is concluded that KK has a claim for breach of contract against MM. Okay. So based on my version and style of drafting the answer for question 1A, you can see that I do not really cite the judgment because citing judgment is a lengthy thing. And what you want to tell the examiner, you must know whenever you write something, you are writing it with purpose, what you want to let the examiner to know. So if you make it clear this way, you can secure a pass lah. Maybe you will not get an A and it's very difficult to get an A. So you can secure a pass because your mind is clear. You get me? But you must cite the relevant section. Because number one thing that we must follow is statute. Statute first, the primary legislation in Malaysia as a common law country will be statute plus case law. Okay, so something like that. Okay. Uh, so second question. Okay, if KK has a breach against MM, you are further to advise KK as to what are the remedies available and type of damages. Damages and damage, they are not the same. Damage means kerosakan ataupun kerugian. Damages normally refer to money. How much money, how much compensation that he is entitled to claim. So these are two different species altogether. Okay. So to advise KK comprehensively, you must think like a lawyer. There are several types of remedies, and remedies are actually defined as what? The ways to solve problems. So you are not going to limit yourself with just civil action. Actually, in real life, many cases, the judge will ask you to settle out of court. Okay, so non-judicial remedies must also come into your mind because you want to show to the examiners that you are a qualified person to enter to the bar. Cool. So how you want to write is that pertaining to non-judicial remedies, KK can try to negotiate. Negotiation is different from mediation. It's two different species. Okay, they can negotiate since they are acquaintance for the past 5 years. Okay, if negotiation doesn't work, perhaps you can appoint a mediator. The nearest one probably is the KL Court Mediation Center or the Malaysian Bar Mediation Center as an alternative dispute resolution for KK, as it saves time and cost for both parties without hassles to go to court. Okay, this is the first part. If you want to discuss arbitration, can, but arbitration will be a bit costly. Okay, and it will be more formal. Okay, and KK could also, you must remember one point. Now, the fact that we are having is that stopped supplying, but this does not amount to automatic termination of the contract, isn't it? So KK is not yet discharged from his legal obligation to pay So what KK must do in the first place is that he must engage a legal firm to issue a notice of termination to rescind the contract. Very important. Otherwise, what will happen is that MM, if let's say, for example, the US dollar stabilize or even drop in the future, will continue to supply the shampoo to KK, and KK will have to pay. But having looking at the scenario is as such, KK already lost the 3 contracts with the hotels, isn't it? He has the money to pay. So your point is to cover the back of your client. So to avoid legal repercussion, i.e., being sued for wrongful termination, it is wise for such a notice to be issued should KK wish no longer to be bound by the contract. Okay. And since has repudiated the contract, repudiation means material breach. Okay, means memungkir ataupun melanggar perjanjian secara material. Okay, he had a very serious breach. Okay, that is refused to supply shampoo as a whole lah to KK. It is open to KK. This one also you must explain the effect, because breach of contract, it is up to the innocent party to either choose to affirm the contract, that is to go on with such a loss. Never mind lah, I bear the loss lah. Okay, maybe a few months later, can resupply back. So the contract does not end. He affirms the contract. Alternatively, that is to put an end to the contract. Say, I want to end this relationship. So this is the choice. So based on the facts, okay, be clear, it is likely that KK will opt for ending the contract. Make sure you let the examiner know because he lost the contract with the hotels already. Takkan he want to, continue with the contract, isn't it? So advice as such. Hmm. And as for the judicial remedies, judicial remedies, don't straight away go and discuss, the Hadley-Bessendale test lah, the Section 74. No, no, no. You make yourself think a little bit first. Okay, you can opt to do the following things actually, because you are to advise KK like a senior lawyer lah, in practice for about 20 years. Okay, first thing, you must actually KK could pray for a declaratory order under Section 41 of the Specific Relief Act. For what? Okay, because now it is in contention, whether the contract really exists, whether the court wanted to recognize there is an oral contract between KK and MM. So first you do is in your prayer, pray for there is a valid oral contract between the parties. And second thing, you must pray that MM has repudiated the contract. If you are not familiarized with the term, you can use fundamentally breach the contract in its entirety. Okay, spelling in its entirety. Okay, so this is in kurungan lah. You can put a section 40 of your Contract Acts 1950. And after that, you must also pray the legal position suffered by KK. KK has lawfully terminated the contract, and subsequently, what is the effect of such lawful termination is that he is officially discharged from his further contractual obligations from the date of breach, that is 1st of April onwards. Very important. Like I say, if you do not do the needful step, you will encounter legal repercussion. In layman term, we call backfire, which is not good for your client. And the contract is rescind for breach on 1st of April 2024. Okay, rescission is somehow or rather, from my little bit teaching experience, I realize a lot of students is not too comfortable with this word. Okay, rescission, there is two version. Number one, rescission ab initio. That means to say the contract go back to the original position, as in never exist before. Okay, like this. A very simple example is, for example, I buy a Rolex watch for my good friend, Mr. Gan. But this is a fraud deal. Mr. Gan cheated me. This Rolex is a fake one. Okay. So in return, okay, I paid, for example, 30,000 ringgit. Okay. I can pray for rescission ab initio. That is to say, the contracts go back to the original position, as in never exist before. So what is going to happen if I pray for rescission ab initio is that I will have to return the fake Rolex to Mr. Gan, and Mr. Gan will need to pay me back the 30,000 ringgit that I have paid him. So this is one version and one type of rescission. Okay. Whereas in this particular scenario, the deal between KK and MM, it is not on a single transaction. I hope you agree. Every month there is a deal, correct? KK pay MM 300,000 per month in return for 60,000 unit of shampoo, and this deal happens every month. Okay, every month there's a return like this for a couple of 4 months, and they keep good relationship. So rescission from for breach is, for example, if you want to pray, is what happened is on 1st of April, take for example, this is speculative, don't get me wrong. If KK would have paid 300,000 for to MM, but MM did not supply. So this part, this 1st of April thing, you can restore for breach. That means to get back the money that you have paid to MM, because it is a multiple recurrent transaction. So this is how it is being applied, rescission for breach. And if there is nothing, that means to say the contract just stop here. Here. 1st of April, everything, no need to do anymore. As simple as that. Okay, can understand me? And second part is compensation. Okay, compensation, you can pray for special and general damages. That is monetary compensation, which will be elaborated in following paragraph, because the second part of the question will invite you to talk about damages and the type, isn't it? Okay. As well as don't forget, you are being given a specific relief act during the examination. So make some use out of it. Okay. Actually, um, KK could pray for a court order to compel KKMM to supply the shampoo to him, okay, pursuant to Section 11 of Specific Relief Act. But in this particular case, and you must remember, specific performance, anything coming out from Specific Relief Act, will be equitable in nature. Okay, equitable in nature means, if you force something to do something, for example, if you give a mandatory injunction to a person to execute the renovation of your house, it will actually cause hardship to the party that being forced by the court to do so. So this is equitable, and it is often not granted by the court in the manner that the damages could be fully paid by monetary award. Okay, be clear with that. So equitable remedy is discretionary in nature. Atas budi bicara mahkamah. Okay, but this is clearly not a good option. Okay, because compensation will be adequate relief to KK. So you conclude saying that the best option is for KK to drop this idea and move on with the monetary compensation issue. And you have to proceed, go on. And damages, damages must be discussed in relation to breach of contract. Okay, so you use a case law, Muralideha Chatterjee against international firm company. Quite a famous case. If that's why sometimes you have read some textbook will mention about Yong Mok Heng and all that. Actually, the original position is provided by one Indian case, for breach of contract. Okay, so if you digest your Contracts Act, okay, let me share the Contracts Act. If you look at the important section, okay, see, it divides into part, isn't it? The drafter, the person that draft this contract, will let you know first how you enter, the way that you enter into a contract, how you deal with people, how people accept your deal. How did you actually convey the terms of the contract to the other parties? So this is in part two. Okay. So part three, they talk about free consent, free mind, voluntariness to enter into the contract. Okay. Then they talk about what are the conditions that can actually negatively influence the free mind. Then subsequently, they talk about the contract that should have not exist in the first place. That is a void contract. Normally, those contracts are from the very beginning itself is illegal in nature. For example, I sell you a pack of cocaine, ketamine, I sell you for $100. There is exchange of value. There is offer and acceptance, but unfortunately, it is not allowed by the law. So this contract automatically diterbata, tidak boleh muncul. Faham tak? Can Okay, subsequently, if any problems arise, they teach you, they teach the innocent party to seek redress. How do you want to get out from this contract? And how do you seek compensation? And how do you restore your contractual position? Okay, so this one is like this. Okay, so this is how apa nama the the drafting goes lah. And you normally need to read up to part 7 of the Contract Act. So you can get a rough idea of how this Contract Act is being drafted. Are you actually still following me? Hmm?
Yes, sir. We
Yeah.
following very
Can
clear.
am I confusing you or can understand what I'm telling?
Can.
Yes.
Can.
Can okay, good.
Again.
Okay, we go on. Okay, so in this particular case, they teach you how to solve the issue when a contract is being affected by the breach pursuant to Section 40 of Contract Act. Okay, so a contract which may be put an end has become a voidable contract. Maknanya contract ini boleh dibatalkan. Voidable means boleh dibatalkan. Boleh cancel lah in a very layman term lah. Okay. So when a party puts an end under section 40, okay, it say section 65. Okay. If you look at section 65, means consequence of rescission of a voidable contract. Okay. Apakah akibat kontrak yang boleh dibatalkan? So section 65 will apply. Okay. So that is rescind lah. So systematically, when the contract is rescind, see the rescinding party, the party that membatalkan kontrak ini adalah berhak untuk menuntut pampasan daripada pihak yang memungkiri kontrak. Okay, understand? So this is step by step how you approach apa nama this breach of contract. Because most textbook that discuss Yong Mok Heng, but how to say, you miss out these three preliminary steps, That's why confused. Okay. In Malaysia, Yong Mok Heng had discussed if anyone that received advantage under the void agreement or the contract becomes void, the other party must restore. This is a bit like the example that I showed to you, KK, MM, because there's a continuous deal. For example, this month, April, he already paid, so he can use Section 66 to restore his bad position. Okay, faham When you look at this contract act in thorough manner, you'll sense something different. Okay. Okay. Nonetheless, you must be a bit practical in the sense that if let's say you want to plead for rescission as a whole, it will be quite hard for the parties. You must think of the legal consequence. If you plead rescission as a whole, that means to say 4 months punya 60,000 toiletries and the shampoo, you have to return to MM. And MM will have to return you the 4 months 300,000 ringgit, that is 1.2 million. This is definitely not a good idea for your client. It will cause inconvenience and hardship. So you say it like this. Nonetheless, both MM have been having transactions of sales of goods for 4 months. It will be hard and inconvenient for the parties to perform restitution and restore all benefits received, because practically the shampoo would have been sold to the hotels and consumed by hotel guests. Okay, so this is how okay, and don't go straight away to section 74 yet. Okay, you must get the legal provision that gives you the right to claim compensation first. Can you understand? Your rights, you punya hak undang-undang adalah bersandar kepada Akta Kontrak 1950. Before you can claim the amount of damages, you can see consequence of breach of contract here. If you look at this, you see Section 76 actually give you this right to claim, correct or not? So your legal position is unshaken. Okay, that means to say you get the right from the Section 76 to claim Section 74 punya two limbs. Can you understand? Okay, so this is how talk about where your rights for entitlement of compensation first. Okay, so this section stipulates a person who rightly rescinds a contract is entitled to compensation for any damage that he has sustained through the non-fulfillment of contract. Okay, so the scope of the damages claimable by KK shall refer to Section 74 of Contract Act, which has codified Hadley against Baxendale test, the two limbs test. Okay. So far, so good? Okay. If you will excuse me for just 5 minutes, I will just take some water and then we come back for what? Just for what? For a
Okay.
while, eh?
Can.
Yes,
Yes,
yes.
sir.
Okay, welcome back. Sorry for the interruption. I think we can continue. Okay. Uh, the thing is very clear. There are two types of damages claimable under monetary award part. Okay, what are them? Don't talk about so much about the expectation loss, reliance loss, all that. Just make it practical. In practice, for commercial contract, sales of good, agreement, etc. Okay, the only things claimable will be your special damages and general damages. As simple as that. Don't talk about those other uh, weird type of headings. Okay, put it very clear. There are two types of damages claimable by KK. Okay, special damages simply means what? Those that could be quantifiable, strictly proof. Okay, again, monetary loss suffer up to the date of filing. Okay, presumably, because you all have to be clear, you must know when are you going to file the suit. Okay, because you are going to draft the statement of claim, isn't it? I will propose you to use 11 November 2024 or your upcoming examination date as the date of filing to avoid confusion, because sometimes you need to calculate and show how much is the loss suffered by the plaintiff. As simple as that. Okay. Be very practical. Okay, special damages. KK can claim pre-trial loss of revenue. That is 1 million ringgit per month. From when onwards? From the date of breach. Sorry. 1st of April 2024. Okay, there's a typo here. Okay. 1st of April 2024 until the date of filing. So you must demonstrate to the examiner that you are coming up with the figure 7 months times 1 million equivalent to 7 million. Apart from that, just be a little bit more practical. Apart from this particular pre-trial loss of revenue, there are some other things which could be proved by receipts, which will be logistic fee, consultation fee, or any other expenses proven with bills or receipts incurred for entering into the contracts with three hotels as well as with MM. Okay, as long as it is not too remote. Okay, section 74 sub rule 2 of your contract act. Okay, apart from that, the second species of damages that you can claim would be general damages. As for general damages, KK could claim expectation loss, which would be if, let's say, for example, now you have to imagine the deal between KK and MM will last 3 years. Okay, that will be 36 months, isn't it? The duly performs contractual terms is only 4 months before the relationship irrevocably break down. Correct? So there will be some expectation loss out of it. If let's say the contracts goes well, by right, KK would have gained benefit from all the contracts that he handled with the three hotels. Thereby, he will earn 32 months of remaining balance of 1 million ringgit revenue. That will amount to be 32 million ringgit as a whole. Okay? But somehow rather, general damages are the key point is this. It will be assessed by the court. The court may not necessarily give you everything that you want. Okay. So it will be the remaining, okay, the judging the fact, okay, you must also be sharp lah. Okay. Let's say in this particular scenario, remember the prior conversation that ultimately lead to the formation of this contract is that knew KK was procuring the deals with the hotels. Therefore, this claim well fitted under Section 74 sub rule 1 second limb. Okay, as the damages was well within the contemplation of the parties. Meaning to say, yes, I don't supply to you, but I do not know your total revenue, isn't it? But here, has prior knowledge. Okay, it's like this. The relationship is between and KK. And KK formed another relationship with 3 hotels. By right, the loss suffered by KK throughout this deal has no business uh, on part of MM. MM is not liable, okay, because the relationship is this. Why should I cover for the loss that you have suffered because your deals with the 3 hotels were ended? Okay, this is how you claim. Okay, you must be specific and you must claim with second limb of section 74 sub rule 1. And furthermore, these are not remote. Then you entitle for this 32 million ringgit. Okay. And furthermore, if you look at the text itself, other business partner of KK will stop doing business with him, isn't it? So this sort of pecuniary loss, is it too remote? I would say this is extraordinary loss beyond the contemplation of the party. Because why? From the first paragraph itself, only knew about the hotel supply contract, the 3 years one. Okay, but he has no detailed knowledge, of KK's other commercial arrangement, i.e., with the gymnastic operators and also other hotel business. So those additional losses, despite really have suffered by KK, should not be claimable. Okay, so you can conclude in such a way. Okay. Okay. Another issue that you must also consider is that KK has been in this industry for 10 years. These KK toiletries will automatically enjoy some fruits of goodwill and reputation, isn't it? Due to this breach of contract, KK has caused termination by 3 hotels, and he would have indirectly suffered from reputational loss. But in conventional, according to case of Alice against Gramophone and one case in Malaysia, CCA Holdings against Palm Resort, those type of reputational harm normally is not recoverable. Okay, so you can conclude it is hard to justify that MM's default could give rise to pecuniary loss as stipulated above. The nexus is simply too distant. Okay. Other type of money that you can claim will be interest this form an important element in our statement of claim, and this is also monetary compensation. So interest is quite simple. You can claim pursuant to section 11 CLA the pre-trial judgment, and also 5% post-judgment sum interest until the amount is fully realized or fully satisfied by the defendant. Okay, so interest, please mention, don't neglect, because all those are marks. Okay, apart from those principles that you have discussed, you must also elaborate further what are the potential factors that can affect the quantum of damages claim. Okay, first part, you cannot take advantage of civil action for your whole benefit. Okay, as far as it is concerned, as a prudent and reasonable businessman, you must learn how to mitigate the loss. In simple word, you must cut loss. Okay, you see, in this particular case, the shampoo itself is not an exclusive item, isn't it? You can get source elsewhere. So by right, KK should have exercised its due diligence to source its substitute or replacement and to minimize the loss at the moment the breach occur. Okay, so as the first information, we don't say notice lah, because later we are going to say there's no notice. The first information that MM convey to him the intention to cease supply was actually on 10th of March 2024, isn't it? So you must estimate what is the opponent's counter movement. So they will say, I will already notify you on 10th of March 2024 that I will not supply you, but you did not take any step to prevent your loss. It's at your own liability, not mine. So this will be the counter move. Okay. So another case to support this will be Kapatasan timber extraction against Chong Fa Xing. Okay. Another challenging point, if you look, okay, if you look and you be realistic a bit, is that this breach itself, although it has happened, but initially could have been prevented if, let's say, KK would just top up another 60,000 ringgit per month, isn't it? If, let's say, KK accepted the deal of isn't it? KK, because of fluctuation, isn't it, of the US dollar, you accept the 360,000 ringgit deal. The breach would have never happened in the first place. So there might be an issue of novation contract, Section 63 of Contract Act. Okay, as a high side, of course, KK would just lost 60,000 ringgit. Instead, the whole revenue of 1 million ringgit, isn't it? So as a reasonable businessman, you conclude that he must take reasonable step to minimize the loss that he suffer. Okay. So another important point is the date of assessment. Why is that so? I think I have elaborated to you. This is a continuous deal between and KK. So when does the breach occur? We will submit it is on 1st of April to justify our pre-trial damages and also the quantification of our subsequent interest, isn't it? The earlier you can prove the breach, the earlier is the money start calculated. So this is the general principle. Okay, but anyhow, it is at the discretion of the court. Okay, but I will submit 1st of April. Okay, because the actual breach happened. Okay, another issue that you must not forget is that whatever the revenue comes into KK toiletries must be subject to income tax SST. Correct or not? So this will be deductible if there is any tax payable on part of KK. Okay, he will not get the full sum like that without the need to deduct the tax. Okay, so Daishawa case. Okay, so in conclusion, KK's strongest course of action is to terminate the said oral contract. Number one is that by way of formal notice, then seek for, because this is a 25 marks question, isn't it? Very high. Almost half of your, apa nama, half of the questions are here. So you must draft a significant conclusion to impress people, you know. So you conclude everything. Okay. Then pursue judicial relief in High Court by way of writ. And then he should have plead the one that I've told you, declaratory orders, okay, damages, okay, and then whatever is it, you must also argue for this. MM can argue failure to mitigate, okay, specific performance not necessary, and then you must take into accounts of interest, mitigation, tax, and also the assessment date issues. And then KK can present a coherent claim. Wow, you see, this is the way lah. See, remain open to negotiated settlement or mediation to save time and cost. Give an impactful summary of what you have said above. Okay. Again, I can't stop to emphasize enough. From this particular answer, you don't see too much case law, but this is apply the legal principle. The landmark case you memorize, and the most important point is that you must know what you are doing. Okay? Clear? Hello?
Yes, sir. Very good.
Can can
Yes.
proceed
Yeah, yeah.
Okay. Okay, good, good, good. Okay. Okay. Now you are asked to go to the last part of the question, which is statement of claim. Statement of claim, also make it a habit. Don't write like a hair wire piece of paper, you know. Please use capital letter for the entitlement. I have not seen any statement of claim is drafted in just small and this capital form. Okay, please make sure the jurisdiction is correct. This case, special damages is already 7 million. Upcoming expectation loss is already 32 million. So no doubt, confirm, isn't it? You have to start in High Court. Okay, where is the High Court? MM is staying at Bangsa KL. Automatically High Court KL. You will not be wrong. Okay. Don't just write in the High Court of Malaya at Kuala Lumpur, you know, it's wrong. You must go to the rules of court. You flip through the borang belakang, ada borang tau. Borang satu, form 1. You tengok betul-betul dia punya format macam mana. So it's like this, you know, in the Federal Territory of Kuala Lumpur, comma, Malaysia.
Doctor, sorry,
The
doctor, where you said Borang one, where, doctor?
rules of court.
Okay, thank you, doctor.
Rules of court. Ada read tau. Read belakang ada. Okay, well many people won't read lah because this is a practical thing, you see. But we got it wrong, then they will struck it off. Susah, we have to repay the money to refund. Okay, and Where were we? Okay, so you must use this civil suit number and then dash 2024. For your convenience, you just dash 2025. Don't need to put in number. And between, because this is a sole proprietor, you must sue in individual capacity. But normally in practice, we put like this. Okay, this is under individual capacity. You put the name, real name of King Kong, NRIC, then subsequently you said sole proprietor trading under the name and style of KK Toiletries, SSM number, uh, plaintiff, like this. Okay, to identify who are the plaintiff and as well as the defendant. Be clear with that, huh? So statement of claim, underline, all these are capital letter. So after this, when you start to draft this statement of claim, you must start with numbering one first. Okay. First paragraph, introduce parties. Who are the defendant? So very simple. The plaintiff is a Malaysian individual whose residential address is at KL. The plaintiff is a sole proprietor trading under the name and style of KK Toiletries. And what this fellow do? At all materials times, KK Toiletries has tracks as wholesaler of home care and personal grooming for the last 10 years. Okay, put in whatever information that is available to you, because sometimes yes, even though we say reputation cannot be claimed, isn't it, in our discussion, but in practice we will try to help our client to get, even though there's slim chance, but we try. Okay, put those things, it will be relevant later. The defendant is a Malaysian individual whose residential address is at, okay, where is it? The defendant is a sole proprietor trading under the name and style of MM's Hairdressing Salon. At all materials time, MM Hairdressing Salon provide hairdressing treatment, supply shampoos, bath gel, and body lotions product. As simple as that. So after that, you use one subheading to explain the background. This is what we do in real life. So plaintiff and defendant have been friends. You can use whatever you want. Acquaintance for 5 years ago when plaintiff was her regular customer. You see the wording that I cast already. The defendant was fully aware of the business nature of the plaintiff. This is I I reserve a chance to claim for reputational and also the so-called the other unassociated business loss already. I reserve myself already. Okay, so be a bit how to say, be a bit comprehensive in drafting the statement of claim. So what happened on 31st of May 2024? Defendant came to know that, you see, this one is already, I want to claim damage suffer, had obtained 3-year contract for the distribution of toiletries product for to 3 different hotels. The 3-year contract required plaintiff to supply shampoo, bath gel, and body lotion product. Okay, see, subsequently, terms of the contract, what they have agreed. So during the conversation of the same day, that is 31st May, it is agreed between the parties that defendant list down the obligation clear. Defendant supplies 60,000 unit of 50 mini pack shampoo every month beginning from 1st of November 2023 for a period of 3 years. B. Defendant shall ensure the shampoo is of good qualities and carries the brand of KK shampoo. And C. Plaintiff shall pay a monthly sum of 300,000 ringgit to defendant. Okay, be very clear. No need. Already said paid defendant money sum. Oh. Okay. In discharging his obligation, subsequently you must say your client is good and obeying the law. It is not my fault. Push the responsibility first, like this. Okay. So how he discharged his obligation is that plaintiff has performed its contractual obligations by making payment on time to the defendant. Okay. Then you must highlight the defendant has duly performed its contractual obligation for 4 months until 1st of April 2024. Okay. Subsequently, maybe you can add one term at all material time. The plaintiff alleged that the oral contract is exists and fully enforced, like this. Okay. Subsequently, you have to blame the defendant for her default. Okay. So how you blame her? Okay. Now you must be clear. You have to push responsibility already. You clear your part, you do your job, contract running 4 months. On 1st of April, the defendant was disabled, refused, or deliberately ceased to supply the shampoo for the plaintiff due to the declining US dollar, and its supplier BS Shampoo Sendirian Berhad is not able to supply the shampoo to the defendant at the initial agreed price. Okay. Then subsequently, the defendant thus approached the plaintiff seeking to novate and vary the pricing of the monthly payment from 300,000 ringgit to a higher amount of 360,000 ringgit. However, the plaintiff was unable to accept the deal. So without further notice, this one is very important. Defendant has unilaterally stopped supplying the said shampoo to plaintiff from 1st April 2025 onwards, leaving the plaintiff unprepared and taken by surprise. So you want to make this, wow, very bad. Okay. As a result, the 3-year contracts with the 3 hotels were terminated because the plaintiff was unable to supply the shampoo to them on time. As well, what are the loss? Plaintiff other customer as of those from other hotels gym operators have informed him that they have heard that his contract with 3 hotels has been terminated, and as a consequence they will stop doing business with him. Okay, see, the loss and damage were a direct result of defendant's default and breach of contract. So besides, okay, the plaintiff have out-of-pocket expenses and measurable loss as stipulated below. So you quantify the particulars of special damages like this. Okay. So loss of revenue that we have discussed, the logistic, legal consultation, and other miscellaneous fee that should have incurred, and subsequently you total up as ABC. Don't spend too much time, just write XYZ. Okay, and the plaintiff claims. So these are the remedies that you have already discussed. Declaratory orders, the contract is valid, defendant breach materially, plaintiff lawfully terminated and no need to perform his contractual obligations, and the contract sudah terbatal pada 1st of April 2024. Okay. Subsequently, second heading of the prayer, you said special damages, how much? General damages, interest, cost, and such further and other relief as this honorable court deems fit and proper to grant. And this one, please put put a date, don't leave it empty. Put the examination date, please. Okay, then you sign. Sign, you must sign, you don't leave empty. Then one garis here, solicitors for the plaintiff, and at the end of the page, you write like this. This statement of claim is filed by Tetuan. Just choose your own name. Tetuan, for example, Ng and Co. The solicitors for the plaintiff, whose address for service, put your house address lah, and your phone number. Okay? In every single paragraph, please do spacing. Don't mix up and then make this one very difficult to read. This is in your rules of court, your pleading rule. And one more reminder, whenever you write the sum, you must write in full numerical amount. You cannot write, for example, which one? Okay, this one, 7 million, isn't it? You want to save time. You write 7 million. This is wrong. Wrong. Technically wrong. Okay, you must write in full. Okay,